Again, our coverage begins tomorrow. Let's bring in Court TV anchor Michael Ayala, who's been getting us ready for this. So tomorrow's the day. Where do we stand as we sit here tonight, the night before?
All right, well, late this afternoon, Majority Leader Charles Schumer released a Senate resolution outlining the plan for the second impeachment trial of former President Donald Trump. Now, here are the terms as agreed to by the Senate. Senators will be taking care of other business in the morning and turn to the impeachment proceedings in the afternoons beginning at 12. Now, Tuesday, they'll start at 1, and there will be 4 hours of debate equally divided between the sides to argue the constitutionality of the trial. A simple majority will decide if the Senate has jurisdiction. If the majority votes in favor of a trial, it will continue. Now, beginning on Wednesday, each side will have up to 16 hours to lay out their case. They will have no more than 2 days to do so. Each day's presentation will not exceed 8 hours. Following the presentations, the senators will have 4 hours to question the two parties. Questions are generally done in writing. And following the Q&A, there will be 4 hours of arguments on whether to consider motions to subpoena witnesses or documents. If the Senate votes in favor, the Senate will then vote on any such motions. And if witnesses and documents are allowed, both parties will be allowed to prepare and conduct discovery. Now, as the trial comes to a close, 4 hours will be equally divided for closing arguments. Then it will be time for deliberation, if requested, and finally, a vote. And Vinny, senators will not have to be at their desks for the hearing. Due to COVID social distancing rules, they can watch from the public gallery, which will be empty, or on TV in nearby rooms. They will have to be in their seats for the final vote.
All right, so what can we expect to see and hear from both sides here?
All right, well, the House manager's case is in part about incitement and in part about the riot. So video of the insurrection will most certainly make up the emotional center of their case. They will play plenty of video of the attack, like the one we just played at the beginning of this segment. And as far as proving incitement, the House managers will play parts of the January 6th speech by Trump, and they will painstakingly highlight the actions of the president leading up to the January 6th insurrection in video, tweets, and recorded phone calls to election officials. Now, the defense, they will focus their efforts on a few strategic areas. They will argue the proceedings itself are unconstitutional, that the Senate cannot proceed against the president out of office. They plan to argue that he bears no responsibility for the riot and that his speech was simply political speech protected by the First Amendment. Now, to this point, they plan to argue that the president believed and still believes that the election was stolen. They claim they don't have to prove it's true, but rather Democrats must prove it is not true. Now, I found this part of their argument, Vinny, very interesting, so I checked in with Stetson Law School constitutional law professor Lou Varelli to find out what role truth will play in this proceeding and whether it matters if what the president said is true or not, or if he believed it was true or not.
If you are guilty of inciting violence, then it doesn't matter if what you said is true or not. If you are inciting people to imminent violence, then we don't permit you to do that, even though you generally have a right to free speech. It's an aggregating factor, and that's a good way to characterize it, though it may even be an understatement. So to characterize what the president did here, he has an oath to uphold the Constitution. The Constitution requires a presidential election. A overwhelmingly legitimate and valid election was held. There's no evidence that the election was in any way illegitimate or inappropriate or fraudulent. He persisted in this narrative, called a meeting on January 6th that didn't need to happen. That meeting was entirely his own doing, down the street from the Capitol, where a constitutionally mandated joint session of Congress was taking place with effectively every important leader except the president in the building at the same time, and engaged in rhetoric that led to violence. That is exactly what the president is not permitted to do under the Constitution, is draw into question the legitimate functioning of our democracy for his own benefit. That is impeachable. So the fact that it was a lie is critical because he was lying about something fundamental to both the democracy and his oath.
Now, the defense also plans to use video in their case. Bruce Castor, who is one of the attorneys for the president, has gone on record as saying they plan to use video showing Democrats using similar language to that used by the president, which did not lead to much blowback in Washington. In particular, he cites Vice President Harris expressing support for protesters in the Black Lives Matter movement and Maxine Waters at a protest outside the Wilshire Federal Building in Los Angeles. So take a listen to what she said.
have members of your cabinet that are being booed out of restaurants, who have protesters taking up at their house, who's saying no peace, no sleep. No peace, no sleep. Let's stay the course. Let's make sure we show up wherever we have to show up. And if you see anybody from that cabinet in a restaurant, in a department store, at a gasoline station, you get out and you create a crowd. And you push back on them. And you tell them they're not welcome anymore, anywhere. History is not going to be kind to this administration. But we want history to record that we stood up, that we pushed back, that we fought, that we did not consider ourselves victims of this president. History will record that while he tried to step on all of us, we kicked him in his rear and we stepped on him.
So Castro says he's been watching a lot of video. You could see a lot of that type of video at this hearing. But Democrats think the entire approach by the defense is meant to deflect from the real issues. Take a listen.
Well, these are false equivalencies are completely without merit, and they're absurd. This is one of the greatest crimes ever perpetrated upon a democracy in the United States Congress by a president. And I understand why some of the supporters of the president don't want to talk about the facts. They don't want to talk about what happened. They don't want to talk about January 6th because it's so horrific. It's so egregious. They would rather talk about anything else, whether it's something in the past, whether it's about their meritless constitutional arguments. They don't want to address the 6th because it's really bad for them. But we're not going to sweep that under the rug. We're going to talk about it, and we're going to put it on full display for the Senate and for the American people.
Of course, Vinny, that was Congressman Jason Crow. He's a Democrat from Colorado and a lawyer who acted as the impeachment manager in Trump's first impeachment trial.
Yeah, what's interesting here in what the defense is doing by playing the videos of other politicians making speeches is it seems the argument is, well, they didn't result in X, Y, and Z. The problem is the speech itself, is what is protected, what is not protected, and what precedent would this set? For instance, if one of those people at Maxine Waters' get together there, or someone who was watching it on TV went and took out some action, I mean, would she really be responsible for that?
Well, they're asking, and what they're saying is, be careful with the doors that you open here, because that's exactly what the defense is saying. Is that the type of republic you want? That you can't have any type of political speech that perhaps leads someone who, as Trump is saying in this case, went on their own and did something that amounted to a terrible crime. Do you want politicians then to be held responsible?
Right. It's very dangerous because it's politicians who were doing it. And okay. All right. What more do we know about the schedule, and will the former president testify?
All right. So one of Trump's attorneys, David Schoen, has requested not to work from sundown Friday through sundown Saturday in observance of the Sabbath. Now, Charles Schumer has agreed, so the Senate will meet on Sunday, February 14th. Now, as far as Trump is concerned, last week there was a letter sent to Trump from the House managers asking him to testify. Now, through his lawyers, he did decline, so it doesn't look like we're going to hear from the ex-president. But House managers did say that they will use the fact that he doesn't want to testify against him, that it creates a strong adverse inference against him. So once again, I had to check in with our expert, law professor Lou Varelli, on this idea that not testifying can and will be used against Trump. We know criminal courts, they don't like it, they frown upon it. So why should it be allowed in this impeachment trial? Here's what he said.
I think is exactly the kind of question that people should be asking, right? Because the impeachment process is a political process and not a technically legal or certainly judicial process, right? The impeachment process is designed to ask whether the president engaged or any official engaged in a high crime misdemeanor, which, as we've talked about, does not necessarily have to involve a technical crime. So it's up to our political leaders to design the rules. Whether or not there's going to actually be a presumption that the senators are going to be instructed to follow, I think still remains to be seen, at least in the final stages. But it is entirely up to us to judge whether we think that's a good idea, because we are supposed to be judging our political leaders in their conduct because we are the ultimate check on them through elections. But I do think it's a fair question to ask whether it is worth it to try to make an argument for this presumption. And we should just rely on the evidence that we already have on video and in transcripts to evaluate what the president did on January 6th and immediately before and immediately after.
Now, the defense is calling the entire proceeding nothing more than political theater, but Democrats insist that even though they may not have the votes, they will need 17 Republicans to agree to convict. The proceedings are still important to create a historical record of the event.
Yeah, what you just talked about there floored me, that we're going to use you didn't testify against you. So there goes the Fifth Amendment.
Yes.
Constitutionally protected speech out the window, the First Amendment. Are we going to presume the accused guilty also? I mean, how far do you want to throw the Constitution out in order to protect the Constitution? To me, it's amazing. This is going to be wild. This is going to be wild, Michael. And it all starts tomorrow, right?
Yes, it does. Tomorrow, as I said, tomorrow it's going to start at 1. Normally, they'll be starting at noon, but tomorrow, I believe, word has it, they'll be starting at 1 p.m.
All right, gavel to gavel right here in your front row seat to justice. Thank you, Michael.